Hello and welcome to Triage, timely conversations for healthcare professionals, a podcast created and produced by K&L Gates. Each episode is designed to highlight important developments in health law and analyze the impact on our clients and friends of the firm. We hope you enjoy this podcast.
Welcome, everyone, to Triage. I'm Desiree Moore. On behalf of my co-presenters, Gina Bertolini, Jackie Hoffman, and me, we are so happy to have you with us. Today, we are going to talk all about data security incidents and data breaches and their increasing impact on the healthcare sector. I think this is something that Jackie and Gina and I could talk about for hours, but one of the wonderful things about this particular Triage podcast that K&L Gates has put together is that we aim to share substantive information and knowledge in a truncated time frame. So let's jump in and stick to that promise. I'll start by setting the stage here a little bit. I think this scenario will probably be familiar to many of our listeners. A client calls us, in this case, for purposes of our hypothetical, it's an ancillary healthcare provider. The client has had a security incident of some sort. It's in the early hours of the incident, so they're unsure of the depth of it and scope of it as of yet, but they know that it's a ransomware event where certain of their systems are locked up, files are encrypted, and their business operations are significantly interrupted. So this is the scenario that we'll be referencing throughout this podcast episode today. And Jackie, before we dive in, we built this hypothetical around an ancillary healthcare provider, but does that carry over to, others of our listeners and other clients?
It really does, Desiree. Thanks for asking that question. I think that a lot of our listeners are probably familiar or expect that there is rigor in this area around traditional healthcare providers and some of their relationships. But in particular, given the expansive nature that we're seeing in cyber activity, as well as providers who operate in a cyberspace, we're seeing that there's a lot more activity for Gina and my purposes also in the HIPAA area that we're going to talk about with organizations that are not what we think about as traditional providers or what we call covered entities and business associates. And the reason that's also important is that business associates who are often these non-traditional providers that are downstream from covered entities or owners of the kinds of information we're talking about, they've got some pretty significant compliance requirements as well that mirror covered entities. And so as we start to talk about that, we want to be sure that those non-traditional clients or parties or organizations that don't often recognize they're in this space take a look at the relationships they have with owners of this type of information and be sensitive to the fact that these compliance issues are going to apply to them as well.
Thanks so much, Jackie. That makes really good sense. And I think that's very helpful that even where you may not be sort of a traditional covered entity, but you are a business associate or otherwise, that your kind of ears are perking up here for this purpose. So let's dive back in. A client calls. What happens next? First, the client has done the right thing by kind of going to counsel first or engaging counsel first. In a security incident scenario, you want counsel on board from the beginning. You want counsel orchestrating the various actions that the company needs to take while also being mindful of the regulatory and other legal implications, for the healthcare provider, both in the short and long term. And it's protective of the organization to have that outside party kind of directing activity so that you can kind of point to and rely on outside counsel and their work if and when, there's scrutiny around the incident. And, I think in highly regulated industries, such as healthcare, this is particularly important. And so from there, counsel will want to liaise with internal IT teams to get a sense of the work that's been done. They're on the front lines. They're going to know a lot about the security incident in those early, hours. And then in some instances, counsel can ensure that your internal IT teams are standing down to make way for third-party forensic teams to come in and assess the nature and scope of the incident. Those teams should be engaged through counsel to preserve the attorney-client and work product privileges where possible. You'll also need counsel, alongside, business leaders in the organization to liaise with insurance to notify law enforcement, which is routinely done in a cybersecurity incident, assess whether to do an internal or an external facing statement, depending on the severity of the incident and who might need to be informed, right? In the case of our healthcare clients, it may be that certain individuals need to be informed in order to perform their job functions, or we might want to make a statement to eliminate any risk that employees or patients or other business partners of the provider will learn of the incident from a leak or some other source. As more is known about the incident, the client will likely have to notify individuals and regulatory agencies as appropriate, and counsel can guide through that process as well. I think, I've said a lot, so before I transition over to Gina, I think the takeaway here really is that there's a lot to do at the outset, but there's a light at the end of the tunnel, and good counsel has been through that tunnel many times and will be a key partner for the healthcare provider, as in those early days as all of that work unfolds. And so with that kind of meaty overview, Gina, from a HIPAA standpoint, what is the healthcare provider thinking at this point?
Yeah, so I think that was a great overview, by the way, of sort of the immediate the steps to take and the people to contact. The other aspect of that will be really starting to think about what kind of data has been impacted. And certainly for covered entities or business associates, entities that have data related to covered entities, so some of those downstream providers that Jackie mentioned earlier, what they're going to be thinking about is, do we have data that is protected by state or federal law? And of course, the first thing that comes to mind from a healthcare perspective and a HIPAA perspective is, do we have what's called protected health information? And protected health information is really very broadly defined. I think what some entities fall into the trap of thinking, in particular entities that may be business associates to covered entities. So they're providing services to healthcare providers that allow them to access healthcare provider data, but they're not healthcare providers themselves. And often, in particular, those downstream entities sometimes aren't aware of how broadly protected health information is defined. So protected health information under HIPAA's privacy rule is essentially individually identifiable information that is transmitted or stored or maintained in electronic media. And so that generally, that's almost everything, just given the way healthcare systems operate these days and their use of electronic media. Individually identifiable information is very broadly defined as information that essentially is created or received by a healthcare provider or a health plan. That can include a business associate of a healthcare provider that's acting on behalf of a healthcare provider that relates to the past or present or future physical or mental health or condition of the individual. So the easiest way to think about this, Desiree, is generally any individually identifiable information that is captured as part of a healthcare transaction or as part of a healthcare service is considered protected health information. So this is far beyond just diagnosis information or detailed information about the healthcare. This includes demographic information. It includes names and dates and addresses and states and zip codes. So all of that information includes information about a patient's payer, if they have a health plan or if they're private pay or if they're Medicare, if they're a Medicare beneficiary. So it really is any information that either by itself or coupled with other information could be individually identifiable, and HIPAA defines that very broadly, down to the zip code. So it is important for healthcare providers for entities, whether they're healthcare providers or whether they're business associates providing services to healthcare providers who find themselves dealing with a potential breach, to think about what is that data that is affected, and will then trigger for those entities the laws and regulations and the reporting requirements. And I know Jackie's going to talk about that in a moment. The other thing I'll say that they're thinking about is really not just HIPAA, right? It's also the host of state laws that may apply to information, to data and information, depending on where this entity operates and across how many states it operates. There may be multiple state laws that they have to start to think about that relate to data and the use of data that may define data a little bit differently than HIPAA. And what we found with our clients who are in this situation is, typically you need to map out how is data defined under the various applicable laws, and then looking carefully at what are those reporting requirements for each of the set of laws and regulations that are applicable. And that's maybe a good segue to Jackie to talk in particular around, to the extent there is protected health information that has been accessed or potentially accessed in a breach situation, what steps to take at that point to start to think about reporting requirements.
Thanks, Gina. And I think that the interesting place to start is what you touched on, that some analysis needs to be done to understand the nature of the breach and coming to the conclusion that it's reportable. And we're going to talk today about for HIPAA purposes. And once an organization does that or makes that conclusion, what happens next? The maelstrom of the first days that Desiree talked about may be past, but it feels daunting to figure out how you're going to approach the required notice to the Office of Civil Rights that regulates these types of breaches, what that's going to require. And in the course of doing that, the kinds of elemental pieces that have to be in place, including notices to the public. I think for the purposes of our discussion, we'll concentrate on breaches where there are individuals who've been affected, more than 500 of them, because that requires that the organization get engaged and really take immediate action and report to OCR as soon as is reasonably possible, but no more than 60 days from when the breach is identified. Let me step back also for 1 minute that I think is really important to think about as you start approaching how you're going to respond to OCR, how you're going to notify the people who are affected. The concept of HIPAA doesn't anticipate that there will never be breaches. HIPAA instructs on the importance of doing what you can to prevent them and then doing what you can to mitigate them once they happen. But there is sort of an underlying industry standard that there's an expectation this is going to occur. And so the focus very quickly turns to, as I mentioned, what did this organization do ahead of time, knowing that they had the kind of sensitive information that Gina's defined. What did they do to protect it? And when something unexpected occurs, how nimble are they and able are they to mitigate the potential redisclosure of that information? So I started talking about the fact that a report to the Office of Civil Rights is going to have to be made no later than 60 days from the discovery of the breach. And that is done ordinarily electronically. There is a series of questions that are easy to access on an electronic portal. I mention this because it's something that is worth looking at. OCR doesn't give a lot of detail ahead of time to what one might do to have best practices in place to prevent a breach. But if you start to look at the kinds of items that they ask for in a breach situation, you can get an idea of what kinds of things they think are elemental in demonstrating that you have really taken your obligations for protection of this information seriously. There are questions about risk assessment. There is obviously a question about the facts themselves, but identifying in what is a brief laundry list on the portal itself about what you have already done or what was in place before the breach occurred gives all of us a little bit of foresight about what OCR expects those organizations that are supposed to be protecting this information already have in place as part of their fundamental practices. Having said that, the other thing that one sees quickly on the site are questions from OCR about what kind of notices have been provided to the affected individuals. And not only is it important to think about how those notices are built out, but when they are in the process. We respond to OCR, we give ourselves 60 days, often as long as we can, because some investigation work needs to be done in order to not just simply inform OCR, but to make sure that the required elements of notices to those who have been affected are populated in those letters, understanding the nature of the breach and how those individuals might be effective and what remedies are available to them to now protect their data from additional disclosure after the fact. And knowing that OCR wants to know by the time of the portal submission that you have already made those notices to people who are affected, it tells us also a little bit more about the order of things that need to be done by the covered entity or the business associate who is experiencing that breach. And so, again, looking at the portal early on and quickly gives us a little bit of a roadmap in terms of how to respond. Once that submission has been made, and I just say this because I think it seems daunting to the recipient of the OCR response back, or who organization that has submitted through the portal, very quickly they are assigned an investigator, and that is often quickly followed by a lengthy set of questions about the practices at the facility and what kinds of remediation have been done and what kind of training will occur and all the kinds of things that might be relevant in great detail. Those questions we have found in our experience are fairly standard. They're important. Being responsive to OCR is critical at that stage, but it is often daunting to receive what is a multi-page and often looks like a discovery request. I just wanted to raise that because that is frankly part of OCR's standard response to a breach notification, whether it is 500 people, whether it is 5,000 or more. The immediate steps are to open an investigation, assign somebody from OCR to work with counsel and the organization, and to follow up with these very in-depth questions that might otherwise seem intimidating, but are a natural part of the process. And with that, I guess I will ask my colleagues if they want to add on, given that it has been the experience of all of us to work together in coordinating our efforts and our areas of expertise to respond to these breaches. And, Desiree has often brought her expertise along with recommendations for bringing in external resources that lend some objectivity and credibility to the tasks that the party that's experienced the breach have gotten underway in being able to go forward and explain to OCR not only their immediate response to the breach, but their go forward planning in terms of preventing another event like this.
Jackie, this is Gina. I'll actually jump in, and that is a great segue to something that I think we should touch upon. You just mentioned bringing in parties for objectivity and, an outside perspective. And I think that's really an important aspect of one other item I'd like to briefly mention, and that is the question of, is an access of PHI, an impermissible access of PHI, a breach, right? So we talked about initially when you have this cybersecurity event, what are you thinking about? And you're thinking about what data is accessed. And then we talked about, you just walked us through very eloquently sort of the reporting obligations and really understanding what those reporting obligations are early on in your investigation, because that will also inform the steps you take and the things you do to prepare, to not only to notice affected individuals, but then to prepare for a potential government investigation. But the really important in between there, as you're looking at the data that's accessed and then you're thinking about reporting, if from a HIPAA perspective is it a breach? And this is also an aspect of the analysis that sometimes people can get a little bit jumbled in, or, can get a little bit lost in. Under HIPAA's breach notification rule, the definition of breach is essentially an impermissible access or use of PHI that compromises the security or the privacy of the PHI. And that latter part of the definition is really important, right? It is compromises the security or privacy of the PHI. So theoretically, every impermissible access or use of PHI will not necessarily be a breach. Now, I say that theoretically, or I added the word theoretically, because I think we need to be careful here. I think it's easy if you are the entity involved and you understand the ramifications of a breach and that there will be reporting requirements. There will likely be questions and requests for information posed by the Office for Civil Rights. It's really easy to look at that access of PHI in a way that's very favorable to the organization, meaning potentially this isn't a breach, right? That the security or the privacy really hasn't been compromised. And that's where it is really important to look carefully if you're handling that analysis internally, to look very objectively and carefully at that question. And I think it's actually really highly recommended. It's a great practice to get outside counsel to help you with that analysis so that you can get some external view, some additional objectivity to help you with that risk analysis. I've helped many clients, and I think the initial tendency is often, nope, it's not a breach, we're okay. And when we really look at the type of data that's accessed, how it's accessed, the length of time it's accessed, et cetera, sometimes we do really land on the side of that it is likely a breach and it is likely something that needs to be reported. So that's a really important part of the investigation. And when you talk about, accessing third-party resources like outside counsel and forensics experts to help with the investigation, I think, again, that objectivity they bring even to that part of the analysis, the risk assessment of is it a breach, is really, really important for our clients to understand.
Thanks so much, Gina and Jackie. I love talking with you both. You're so knowledgeable on the HIPAA side. And as Jackie said, the three of us often work together to holistically solve the crisis of a security incident when our healthcare clients do experience it. So with that, let's wrap on kind of the hypothetical that we brought forward at the beginning. We will have investigated the incident. The client will have restored systems and returned to business, which is always our kind of primary or one of our key objectives in any security incident. We will have worked together to notify regulatory agencies and individuals as needed. We will have worked with insurance and engaged those third-party cybersecurity and forensic firms that Gina and Jackie talked quite a bit about to support any submission to OCR and other regulatory agencies. And this work is ongoing for some time. But again, in the early days of an incident, all of this can be so daunting. And what we've tried to do is distill it down to a few quick minutes. Maybe we've gone a little longer than that, but to illustrate that the work can be done. There is a roadmap and you will get through it. It's really not a matter of if, but when. And the test here is not, whether you've been the victim of a security incident, but how you manage the security incident in the aftermath and what you do once it comes to your attention that there is a potential incident on your hands. So we hope that this overview gives you some orientation around how a security incident can be managed and gives you some insight into the process sort of start to finish in an expedited fashion. We are so grateful that you were with us today, and we look forward to being with you next time on Triage. Thanks so much.
Thanks again for listening to Triage, timely conversations for healthcare professionals. New episodes are available for download through Apple Podcasts, Google Podcasts, and Spotify. By subscribing to Triage, you will receive timely notifications for each new episode. Also, if you have any topics you would like to hear discussed on Triage, please don't hesitate to email triagesupport@klgates.com. We would love to hear from you.